5 suspects linked to the murder of former Orlando Pirates captain Senzo have been arrested. He was gunned down 6 years ago today at the Fossler's home of then-girlfriend singer and actress Cathy Mohlahlana. Police claim a weapon retrieved from one of the suspects is strongly linked to the firearm used on the footballer. Joining us to discuss the criminal procedure is criminal attorneys Marius Toit and director and Ulrich. They're going to be joining this conversation. Good evening to both of you, gentlemen, and thank you so much for your time. Marius, maybe let me begin with you here. It's 6 years on. It's a case that's now being described as a cold case. It's a cold case unit that we're told investigated this. Does that change how the prosecuting process is going to work?
I think the biggest difficulty when you have a lapse of time in any crime, Cathy, is the fact that memory fades as time goes by. So when you deal with witnesses that observed certain things or witnesses that had to identify certain things, as time goes by, it becomes really difficult to properly have that evidence adduced in court. When it comes to physical evidence, when we talk about ballistic evidence, when we talk about fingerprints and things like that, then of course, time in itself would have no impact on it. Because then you can still adduce the evidence will still be fresh, because at the time when the report was done, or when the ballistic report was done, at that time, of course, the evidence would still be acceptable in court. So I don't think in that regard it would have a difficulty, but when it comes to oral evidence, of course, time is always an accused's friend, because memory fades. And I think that will probably play out at a later stage in the trial.
Ulrich, does it matter that the foundation of the case has changed quite fundamentally? It's moved from having been an attempted robbery to now being an assassination, a hit. Does that change the schedule of offence that has been committed here?
Hi, good evening, Cathy. Good evening to Marius as well. No, not really. When you refer to schedule, that is only applicable to bail applications. So it would either fall under a Schedule 5 or a Schedule 6 offence. Schedule 5 meaning that it is murder, whereas Schedule 6 would have been murder, preempted murder or premeditated murder, meaning that there would have been a plan, as you rightly put it, to assassinate the deceased person. But that would not affect the investigation as such. Fact of the matter is that whether there was only a robbery or whether there was no robbery at all, there is still a person who has been killed unlawfully. So the investigation of the police will be as possible in order to prove the allegations beyond a reasonable doubt. And just to add on to what Marius said earlier, our criminal justice system is based on testimony, which is done in an open court, and we call it viva voce evidence. So it is the ability of witnesses to testify in court and to accurately recall as to exactly what happened when they witnessed this alleged crime taking place. And the state needs to prove their case beyond a reasonable doubt. So obviously, as Marius points out, people's memories fade. But if affidavits were taken soon after the commissioning of the alleged offence, then one would expect those witnesses to be able to accurately recall what they said in their affidavits shortly after the alleged crime was committed, and for them to then be able to accurately testify in an open court as to what happened. But certainly, and I think Marius would agree with me, we've been involved in many cases where the prosecution would have only taken place quite a number of years after the alleged offence had taken place, and where the state would still have been able to prove their case beyond a reasonable doubt.
Ulrich, what is the legal test that the state is going to have to pass in order to secure a conviction on assassination or a hit-related charges?
Well, they would have to show that there was a premeditated plan to execute the deceased. So in other words, they would have to be able to obtain evidence, whether it is physical evidence in the form of, for instance, written notes or diaries or notebooks in which a plan was made to assassinate the deceased person. And that would have to be bolstered by possible witness testimony, so viva voce evidence in an open court, as to whether this plan was indeed made prior to the person being killed, and the plan then carried out accordingly. But when you say what is the test, we refer to it as the onus, and the onus on the state is to prove that the murder was committed beyond a reasonable doubt, whereas on behalf of the defense, the 5 accused who have now been arrested in this matter, they would have to show, if they were to testify down the line, that the version which they present to the court is reasonably and possibly true. So the onus on the state is different in that regard.
And while we are having this conversation, we're watching live visuals of the Police Minister Bekele arriving. This is at the Senzo home in Umlazi tonight. It's, of course, raining out there, and we're watching live pictures from that particular household. Our reporter, Karinda Jagmohan, is on the ground, and she's watching these developments. We're going to stay with this picture. I'm speaking to Ulrich, Roux and Marius, Toit, both of them criminal lawyers. Marius, let me come back to you here. Tomorrow you have the appearance at the Boksburg Magistrates Court of 5 suspects who have been implicated in this case. What is the state going to have to do in order to link them to each other and to this case? Do they even have to do that in order to secure a prosecution against all men?
Well, I think the first thing we have to remind ourselves, and let me just say it's lovely to hear Ulrich again. I haven't spoken to him for such a while. But in a matter like this, the first thing the court will consider, of course, is the issue of bail. That will be the urgent matter that will receive attention. And when you deal with something like this, which is Schedule 6, because it's premeditated murder or murder part of a robbery, if it wasn't perhaps premeditated, then you're dealing with Schedule 6. And those circumstances, you can only get bail if you can really show exceptional circumstances. If you are able to show that in this instance, you should be granted bail and that something exceptional is there. Now, typically when you deal with robbery and murder, in a case like this, you would have to show that the evidence against you is quite weak. You would have to show that you perhaps have a rock-solid alibi. You perhaps have to show that, listen, the evidence will not perhaps link you to the murder, or that you were just a person at the wrong time at the wrong place. But in order to do so, Cathy, you have to adduce evidence, and that can be done either by way of affidavit or giving oral evidence. But there's, of course, a big question mark at the time of the bail application when you do that, because all the evidence you adduce will, of course, be admissible, provided you've been warned, but will be admissible at the subsequent trial. So the accused will always be extremely cautious when giving evidence. And you remind yourself back in the day when Ulrich and I were involved in the Oscar matter, you know, Oscar gave a lengthy, detailed statement at his bail application because he had to climb the same hurdle. And in that instance, that affidavit that he deposed came back to bite him at the subsequent trial. So you can only imagine that these 5 accused that are appearing before the court tomorrow would have to be cautious as to what they say about the matter, keeping in mind that they will probably be arraigned in the High Court eventually. And I'm quite sure the fact that this matter has taken so long says to me that it wasn't just the eyewitness that identified them. I think we've got real evidence here. And by real evidence, I refer here to fingerprints perhaps, or we might have ballistics, the fact that somebody was found in possession of the firearm that was linked to the scene. They would have done tests on the casings of the spent cartridges on the murder scene, or whatever the case may be. But they would have to have something objective to suddenly say these guys are linked to the crime. And of course, the onus is on the accused to come and show that exceptional circumstances are present before you get granted bail.
All right.